Hello, beautiful people. Welcome back. It is very easy to think that merely listening or hearing someone is synonymous with actually comprehending what you're listening to or hearing. There's a listening habit that many of us have, whereby we think hearing something or hearing someone is synonymous with actually comprehending it. Perfect example of that is this thing called the Constitution. When you speak with someone, or any bodies of instrument for that matter, when you speak with someone regarding rights, their capacity and standing, they'll tell you what they have heard, not what they actually comprehend. They will repeat things that they have heard or read, not the things that they know the intricacies of. If you ask someone, what is due process? If they attempt to explain what due process is to you, they would limit it to arrest or search and seizure. They will limit it to a specific instinct. When you read the Fifth Amendment of the United States Constitution, it tells you no person shall be deprived of life, liberty, or property without due process of law. When someone reads this or hears this, they will think due process of law is limited to your security, you being able to keep your property, you having liberty, and you not being able to deprive of life. But when you tell them to give you an example, they'll tell you something about mortgage or their vehicle when it comes to property. And tell them to give you an example of liberty, they'll tell you about being able to be free without paying taxes. That all those are applicable. But when you tell them to give you more example, they're not going to be able to explain it. That's because these terms within these bodies of law have specific definitions. Like you read the Bible, and then there's a dictionary for the Bible that goes along with each term. Same applies with law. A lot of us know there are law dictionaries. Yet, most fail to look at the definition of what these words mean, or these phrases and terms. And when that is done with law dictionaries, people fail to realize that law dictionaries are meant to be used to find case laws. Not that you just cite those definitions from those law dictionaries. The word due process has a specific explanation of what it actually means. The word probable cause within the Fourth Amendment has specific explanation of what it means and the terms and conditions involved in probable cause, and how probable cause branches out to different things. We've run over that in the past. But in this case, let's speak of due process. Let's speak of one of the branch of due process. So when it comes to pen and paper game, especially courts, what does due process look like? This thing called due process, where you shall not be deprived of liberty, property, without it. This due process is of something, of law. Due process always attaches itself to a certain type of law. Within the Constitution, it uses a blanket term without due process of law, but there are different types of laws. So the due process and how it's enforced within those different types of laws differ. A good example of that is something called supplementary pleading. When it comes to evidentiary law, how to present evidence, how to admit evidence, and what constitutes evidence, there's something called supplemental pleadings. Regardless of whether you are in a trial court, appeal court, district court, county court, federal court, state court, whatever court, private court, whatever it is, all documents that's placed into that venue are called pleadings. For instance, on a federal level, they are usually very formal. They will give a timeline for one party to respond and the other party to rebut. What if the timeline that was afforded to you, which the uniform version is 21 days, in some cases it could be shorter, but generally speaking, general pleadings on a federal level, the response time period is 21 days. What if that 21-day period has passed for you to respond? And certain things that you ought to have added would affect the total outcome of the case, which would cause something called miscarriage of justice. Whereby if that thing that you did not add within that time frame for you to respond would damage you, what you do is called a supplemental pleading. Supplemental pleading, when it comes to evidence, is due process. A pleading that sets forth transactions or occurrences or events which happened since the date of the pleading. The date of the pleading here made reference to is the initial one that this is now attaching to, with the purpose of supplementing it. To supplement something means to add. It doesn't replace, it doesn't annul, it doesn't void the previous one. It just add on to it. It does not amend it. To supplement something when it comes to evidentiary law, admitting evidence or putting papers in, to supplement it is different than to amend. To supplement is synonymous with an addendum, to add something. The court may permit these through motion. Even if the original pleading was defective, it may still be supplemented. Meaning, you don't even have something new to add. You saw that there was a defect in your previous papers and it was fatal. You can supplement it. But just like you do an amended complaint, whereby you would do a motion for leave to amend, and instead of waiting for them to accept or deny before putting the amended complaint, you actually attach the amended complaint with the motion for leave. The same thing is done with supplemental pleadings. Very simple. I'll be posting an example of exactly what it would look like on the Patreon page. But nonetheless, just know that whatever you put in within any given timeline, according to the principles of due process of law, you can always supplement whatever you put in, even after the deadline. There's always an opportunity to fix an issue. No one is perfect. your autocorrect might have corrected one word, which completely creates the opposite of intent of what you intend to convey. Believe it or not, you could actually use that as a reason to supplement your pleading. Sometimes it really gets that simple. It doesn't always have to be complex. It can be complex, and you can make it complex, and you should make it complex if needed. But sometimes it's just that simple. Supplemental pleading. Nothing is ever final. Due process is always at play. This can be your saving grace in a lot of situations. If you were doing a settlement offer and you put a settlement offer in and you realize it wasn't favorable, you can supplement it. You did a notice of discovery, you can supplement it. You did a response to a discovery, you can supplement it. Because discovery and the response to discovery is basically all about self-confession. And discovery is a form of due process in of itself. You can supplement the response to that or the discovery itself. You can supplement your rebuttal, your answer. You can supplement any given exhibit or material fact that you've put in. Nothing that you initially put in is ever final. And there's a solution to that for you in every corner called a supplemental pleading. But you better have a good reason though. And you better know what you're doing. And whatever it is you're supplementing, it better be firm. And they even tell you within Rule 7.1 when it comes to disclosure of any given statement. Time to file supplemental filing. A party must file the disclosure statement with its first appearance, pleading, petition, motion, response, or other requests addressed to the court, and promptly file a supplemental statement if any required information changes. The strongest stuff within the quote-unquote their rules, as loosely presumed by many, the strong ones are usually in very short and plain statements because they don't want to give it to you too much. They just say it and leave it and keep it moving. Time to file supplemental filing. A party must file the disclosure statement. What disclosure statement? About the way an entity who is a party is organized based on how much they own. But then it goes on to tell you, or other requests addressed to the court. See, they structure this in a manner whereby you will read it as though it's limited to this prerequisite information in item A, 1, and 2. But if it was limited to item A, 1, and 2, A1 and 2, the way legalese are told is written is they will tell you that it is limited to A1 and A2. But if it does not stipulate that the item B is not limited to A1 and A2, then everything that's been said here generally applies. Usually, literally, legalese will tell you it would make reference to the specific section that is limiting the next section to. If it does not do that, you're good to go. And even better, it even tells you or other requests addressed to the court. This right here, for those with eyes to see, is due process of law that you're reading right here, implemented into, quote, their rules. And they're telling you, the moment you do that, file a supplemental statement if any required information changes. Whatever it is that you're changing, add it. Add it to that motion or leave to file a supplemental statement. This is where discernment comes in. They further tell you in Rule 13, when it comes to counterclaims, Rule 13E, counterclaim maturing or acquired after pleading, meaning you found other things that can counteract the claims that is being brought against you. After any given type of pleading, which could be the answer, the rebuttal, the complaint, whatever other type of pleading. Pleading just means any type of paper. You have acquired that new information, or the information that has changed, that has matured, and you can use it as a claim to counter what is brought against you. Rule 13. 13E. Counterclaim maturing or acquired after pleading. The court may permit a party to file a supplemental pleading, asserting a counterclaim that matured or was acquired by the party after serving an earlier pleading. Literally, they're telling you, okay, if it was not a minor error or some type of fatal error, you can use it based on the evidence. Meaning you found a new evidence. You acquired a new evidence or new information, or the previous information that has been changed or matured, and it will affect everything that you had put in prior and the decision that that fact finder or truth finder will be using, will be determining, and you have to let them know about it. It's right there. They are giving you the reasons. They are handing them to you. They also tell you in another part called Rule 15, amended and supplemental pleading. We're not looking for amending the pleas. We're looking for literally supplemental part, which is in 15D. Right towards the end. Supplemental pleading. On motion and reasonable notice, the court may, on just terms, meaning you have to state out the terms and conditions as to why you are supplementing your pleading, and it must be just. So in the process of the whole situation, you enforcing your form of due process, you cannot do miscarriage of justice to the other party. It must be done in good faith. 15D, supplemental pleading. On motion and reasonable notice, the court may, on just terms, permit a party to serve a supplemental pleading setting out any transactions, occurrence, or events that happened after the date of the pleading to be supplemented. The court may permit supplementation even though the original pleading is defective in stating a claim or a defense. Meaning, you can even do this if you've completely screwed up. The court may order that the opposing party plead to the supplemental pleading within a specific time. Meaning now they can reset the clock as to, okay, now this guy has changed the substance of certain things, so now we're going to afford the other party due process to respond to the substance. You say you know your rights, right? Then know the dynamics of it. This very simple document called the Bill of Rights entails so much details, and the explanation of those details are in quote unquote their rules that a lot of people run away from. One word, one sentence within the Bill of Rights or any other body of law will usually entail enough details to write a whole book about it. So if you're saying you know your rights, you better know the details involved, especially when it comes to pen and paper game. Does due process of law involve a lot more than just what we went over? Yes. Yes, it does. But I find that to be an immediate remedy to a lot of issues that a lot of people face. Because you'll find a situation where people go, oh, I filed that. It's too late now. What do I do? People know of amending your complaints. Yeah, sure. But do people know about supplementing your pleadings? Not a lot of people do. Only a very small amount do. So there you go. Any other papers you put into the court record, you can always supplement it. And all the guidelines to it have simply been read and handed to you. I'll be showing an example of exactly what it'll look like and sound like on the Patreon. Take care and best of luck. A quick shout out to my patrons, and to those who have not yet joined my Patreon, I'm inviting you, come on over. On the Patreon page, we speak about things that are not shown here on YouTube. We speak about the private side of the court, outside of just the finance. We speak about how to prove actual fraud and lift the corporate veil. In addition to some study tools, we speak about how to actually invoke private right of action there in the Bill of Rights. We speak about financial things with letters of credit, property rights, preservation of property rights. We speak about how to put your vehicle in a trust and how to not qualify for tax, how to properly fill out the GSA, public laws of the state and common law, how to establish probable cause. There are different types of damages. There's damage and there's damages. Those are two different things. The type of relief that you seek to be granted is a huge part of the type of damages. We go over that. We speak about the details of the bills of right, which is what you would really be invoking whenever you bring in any claim, whether on a financial level, private level, whatever it is. We speak about how to remain private when it comes to the EOSCAR algorithm and how to establish certain types of profile. We speak about how to go after bonds. We speak of how to get federal judges and other federal employees oath of office and bond. We speak about the different types of discharge and the specific ones, and we go over the details and more and more to come. Take care and best of luck.